Hi, my name is Abdul Faruqi. I'm an attorney licensed in Texas and California and a former prosecutor with more than 15 years of experience in criminal prosecution. And I wanted to talk about self-defense insurance. Basically, this is insurance that is offered by at gun shows, places where people buy guns, other places online as well. It's the kind of insurance that you buy if you think you might have to use your gun, because if you do, even if the law is with you, you still have to pay for ancillary costs as a result of using your firearm. Could be a defense, to pay for your legal defense, to pay for cleanup at your home, all kinds of other issues that arise from that. But I also wanted to talk about the need for such insurance because right now there's a lot of laws that protect people who act in self-defense, and I wanted to kind of cover that topic first and then talk about the insurance itself and why it exists. So in Texas and California, we have self-defense doctrines. They've evolved differently across the U.S. states, and it reflects a balance between public safety and individual rights. So this video talks about how Texas and California interpret self-defense laws. There's an expansive no duty to retreat in Texas to California's more cautious approach. Also examines the rise of self-defense legal insurance, such as U.S. Law Shield, USCCA, and basically detailing what these plans cover, how much they cost, and how they compare to general prepaid legal services like Legal Shield. I'm familiar with Legal Shield. I know that some people try to sell it as kind of like a MLM type thing. You become a sales rep and you collect a commission. I'm also familiar with the self-defense legal insurance. It's existed for quite some time. In fact, I prosecuted a case involving a person who waved a gun at someone, and they were basically charged with aggravated assault with a, well, I think it was not aggravated assault. It's been some years, but basically it was a charge threatening someone with a weapon. I forgot the exact charge that was at the time, but I prosecuted several of those types of cases, and I remember one of the attorneys in that case was represented by one of these companies that offered defenses, and he was a decent attorney. He did a pretty good job, but it really begs a question of, will you always get good coverage through these insurance plans? Do these plans encourage people to act in a riskier behavior? And is the source of the defense legal funding admissible or influential in court? Because, in some of these cases, someone might claim I didn't even have a gun, but, the fact that this attorney came from this particular company to defend them, that could be an issue, and obviously a good attorney would try to keep that fact out. But insurance can provide a robust defense in some cases. A lot of people can't afford a criminal defense lawyer, and they have to settle for a court-appointed lawyer, which they can be some really good court-appointed attorneys, especially on the wheel system. In several counties, a lot of the private lawyers are the same ones that are court-appointed, especially in my experience in Fort Bend County, but that may not be true everywhere. There might be some offices that have overworked public defenders. So in some cases, you get what you pay for. But let's talk about the self-defense laws in Texas versus California. So Texas is known as a stand your ground place and a castle doctrine place, which is basically under the Texas Penal Code Chapter 9, individuals generally have no duty to retreat when faced with an unlawful threat if they are in a place that they have a legal right to be. They're not engaged in criminal activity and did not provoke the attack. In other words, if you're in your home, you have a right to be there. You didn't provoke the attack, so if somebody comes at you, you can stand your ground. You have no duty to retreat beyond that point. And that sometimes even extends to your front lawn. Like, you may not even have to go back into your house. If someone picks a fight with you, you can just stand right there in your front lawn and use force, including deadly force. And I've prosecuted cases like this. I've had grand juries acquit cases like this, and I sometimes have recommended acquittal in these types of cases when the self-defense was clear. So I'm not somebody that wants people prosecuted or not prosecuted. I just want the law applied fairly and equally to people. Texas law explicitly affirms that as long as a person's belief of danger is reasonable and immediate, they can meet force with force. The Castle Doctrine in Texas further provides that a person has especially strong protections in their home, vehicle, or place of business. And that's, the vehicle is basically to prevent carjackings in your place of business. Think of convenience store clerks who often get robbed. That's another reason why that law exists. Texas law presumes a reasonable fear of imminent harm whenever someone forcibly and lawfully enters your occupied home, vehicle, or workplace. And that gives you legal justification to use deadly force in response. These are your castles. Could be your truck, could be your store, could be your home. There's no duty to retreat at all. You don't have to go run into a room and lock the door. Texas Penal Code 9.31 and 9.32 codify these principles and even extend the doctrine to certain circumstances outside the home. For example, so giving some examples here. Someone breaks into your home, you're reasonable in using lethal force to stop them. This also mirrors California. You can do the same thing in California, but Texas goes further in important ways. One of them that a lot of people don't believe, but it's true, is that Texas is one of the few states that allows you to use deadly force to protect property. Now, everybody knows you can use force to protect your life, but to protect property seems to be controversial. Under limited conditions, you can do this. Under Texas Penal Code 9.42, a person can use deadly force to prevent imminent crimes like arson, burglary, robbery, or aggravated theft during nighttime, or to stop a suspect from fleeing with stolen property at night. And I believe there was some talk about changing that to even daytime, but I haven't been tracking that bill. But if someone comes to your house and I guess if they take your Xbox, break into your home, take your Xbox, you could shoot them as they're leaving with your Xbox. And for me, I don't recommend anyone do that, killing somebody over that. But the law seems to contemplate that you could. And that's where we get into that insurance defense later on, that you may want to have a policy if you decide you want to act that way. It's not condoning the behavior of the person stealing the property, it's just that it's property, and if you're using deadly force, you're going to enter a world of complications with the legal system over that $400, $500 property. If no other means can protect or recover the property. So that's another thing that you have to consider. Like the first thing you shouldn't be doing is drawing your gun. If there's other means you can use to retrieve the property, that is preferred. For instance, you could, for example, and that's going to be hard to say. Like, let's say you're at nighttime, if someone is entering your home and they're trying to take some property from you, you don't know what their intent is, right? So in that case, you'd be justified in shooting them. But if it's very clear that they're just after your property, your home is vacant, and you catch them taking property out of your home that appears to be unoccupied, that's going to be, that's going to require a little bit more analysis as to what to do. In some instances, people just lock the doors and lock the suspects in and call the cops. If you have an opportunity to do something like that, lock the person in your home, that's a way to detain them without shooting and killing them. But each case is going to be a case-by-case basis. And anyways, in Texas, you can do this. In California, using lethal force is unjustified solely to protect property. So in Texas, you have more leeway to do this. And that's just part of our robust self-defense culture. Now, I can go through a couple of different cases here. In my experience, this is a thing that happens day in, day out. For you to defend yourself, if you shoot somebody in that kind of situation, the best thing you can do is get the lawyer up front before the charges have been filed while the investigation is still going on. One illustration of the stand your ground property defense law is the 2007 case of Joe Horn in Pasadena, Texas. Mr. Horn observed two men burglarizing his neighbor's home, and after calling 911, he went outside and shot both men as they fled. So it wasn't his home, it was someone else's home. In Texas, the law permits use of deadly force to protect a third person's property in some circumstances, especially to stop burglary or theft at night. which became a key point in the case. A grand jury at Harris County declined to indict Horn, effectively finding the shooting justifiable under Texas's self-defense statutes. And I'm not sure that was more than, gosh, that was 18 years ago. Yeah, that was 18 years ago. Harris County grand juries have changed a little bit with the shift in political changes here. So I probably wouldn't rely on that in Harris County to say that you won't get indicted for that kind of circumstance. But that's who makes a decision. A grand jury decides to indict or not indict, and that's something that you have to consider before you act in protecting property, especially someone else's property. In Horn's case, he claimed he feared for his life, but that was something that was on top of the fact that Texas still allows you to protect property even if you don't fear for your life. Each of the burglars was shot in the back while fleeing with stolen goods, which suggests that it wasn't in self-defense of the person's running away with you, but still the no-bill outcome underscores how the stand your ground and castle doctrine laws can shield a shooter from prosecution, even with defending property outside one's own home. And this was a controversial case. They called it vigilante justice, but Texas keeps expanding what is considered self-defense, and people continue to test the limits of the law. But in general, the Texas standard is you got to reasonably fear imminent harm, but you don't have to retreat. Even if you have that fear, you can use force in defense. California, now let's move to California. The California self-defense law and how it compares to Texas. It's more restrictive, as you may guess, compared to Texas, but it doesn't impose a rigid duty to retreat in practice. Texas has no explicit stand your ground statute written into it. However, a person who is attacked generally is not required to retreat under California case law, and they may stand their ground to defend themselves. So they have case law that supports that as long as they act reasonably. In other words, so in Texas, there may not be a reasonable approach to standing your ground, but in California, there has to be one. In other words, California courts recognize that if you face an imminent threat, you have a right to use necessary force without first trying to run away, provided you didn't start the fight. And that, as a prosecutor, I've seen that's an issue that often occurs in the criminal law context. Did you start it? And what was the final step before you claim self-defense? So that's where it gets really messy with the facts and the evidence. And many times these so-called self-defense claims usually start with an earlier dispute or some kind of antagonism. But in the 1961 case in Peoples versus Collins and People versus Clark in 2011, they held that there's no legal duty to retreat in California as well. Even the California standard jury instructions tell jurors that if someone is in fear of imminent harm, they can stand their ground. They don't have to retreat. So this is also a de facto stand your ground stance that California has, but it still requires necessity and reasonableness, which is a little bit different from Texas. In California, you need imminent peril. You got to believe that someone else was in immediate danger of being killed or suffering bodily injury. The force is necessary to prevent the danger, and it has to be proportionate. So excessive force is not allowed. But most importantly, California doesn't allow deadly force just to protect property. So, all of this is in the criminal law context here. And even though I handle a lot of civil claims, we're just speaking about criminal law, not about civil liability, which would exist. Even if you're protected from criminal prosecution, you still may be exposed to civil suits for acting in maybe an unreasonable way. So let's move on here to the state's approaches and kind of summarize what happens here. So duty to retreat, both states have it. While California doesn't have a stand your ground statute, it doesn't require people to retreat either. Californians can stand their ground. Lawmakers have talked about requiring retreat, but and California does tend to encourage de-escalation and acting reasonably, but there's no requirement to retreat, whereas Texas takes a very different approach. If someone meets you with force, you can go ahead and do it right back. You don't have to be the reasonable party there. both states have a castle doctrine for their home, but in Texas, it covers not just your home, but your vehicle and workplace as well. And a lot of people in Texas carry guns in their cars. And in fact, I remember seeing a coworker's car. They bought a Toyota Tundra. The dealership was selling I don't think they even sold an option. I think it was just automatic. I think it was a deal. It was a port installed option. Um, the truck automatically came with a gun safe in the center compartment because I guess that's just how many people kept guns. So they just assumed we're going to install them in every truck that's sold in Texas. So neither state requires you to escape your home with the invaders present, whether Texas or California. But the difference is that Texas extends its no retreat zone to occupied vehicles and places of business, where California protection for vehicles and workplaces is a little bit less explicit. So, in the protection of deadly force, as I said, deadly force for protecting property, Texas allows you to do it, but California doesn't. Um, And then in real world applications, these are just a lot of cases you're going to find in Texas where somebody is killed, self-defense is claimed, and then there's going to be a no bill, which leaves you to have to potentially pursue a wrongful death claim if you feel like the grand jury was unreasonable on the criminal side of the case. So Texas law gives defenders more benefit of the doubt in these types of situations, but even so, let's talk about the next part. So let's talk about the rise of self-defense insurance in the U.S. So, in recent years, there have been a lot of different insurance products, but one of the fastest growing ones is self-defense insurance, and it's necessary in those situations where people who own guns might have to use them in self-defense. Approximately in 2025, this year, 2 million Americans have self-defense insurance or membership programs. And this is a doubling of membership in the last 5 years. And several factors drive this trend. First of all, there's been an expansion of concealed carry and stand your ground laws. In fact, in Texas, it's an open carry state. There have been increased gun sales, and high-profile self-defense cases make gun owners aware of potential legal aftermath of using a weapon. So facing the prospect of criminal charges or even the grand jury, even if you ultimately get acquitted, you still need that representation. It can still cost you money, which is why, I would say like shooting somebody to protect a $500, video game system may not make sense when you may have to spend $5,000 or more hiring a lawyer to defend you in that kind of case. Even if you believe it's the right thing to do, it still may not make sense financially. So not everybody thinks that way in the heat of the moment, though. So what is self-defense insurance? It's really not insurance in the traditional sense. They're legal defense programs, so I don't believe they're regulated by the Texas Department of Insurance. I'll have to check to see if they're changing. Depends on how the policy is written, but the U.S. Concealed Carry Association, U.S. Law Shield market memberships have promised to cover the aftermath of a self-defense incident. Member uses force, usually a firearm, but they'll also cover any legal weapon or unarmed self-defense, and they face legal jeopardy. The program will pay for attorneys, court fees, and related expenses, and the benefits include criminal defense lawyers, bail bonds, coverage of civil litigation, damages and legal fees if the defender is sued, ancillary costs like crime scene cleanup and counseling. Many plans extend coverage to the member's spouse and children. That's just common sense, I think. It's great that they cover that because, your kids and your wife might be affected if you use a gun, or your husband, depending on who's using the gun. Notably, coverage is usually conditional on the incident being legitimate self-defense. In other words, the policies do not pay out if the member committed a crime unrelated to self-defense. So you still need a colorable argument of self-defense. Now, I'm not sure how they decide if you're in the right or the wrong, but that's something that I find with insurance companies, that if they think you're liable, they're not going to cover you. And so I'd be curious about the appeal process there of, if they got it wrong and you paid for that policy, you want that covered. So how are you going to ensure that they cover you when you feel like you were in the right, but they're reading the facts differently? Sometimes they'll start coverage, but if the evidence shows it was a premeditated murder, coverage would cease. They obviously say they're not going to cover illegal acts. They're going to seek reimbursement if you're convicted of a violent crime, but some of them have softened the recoupment language. So, like for example, if you kill somebody, you claim self-defense, and they indict you, and the jury doesn't believe your self-defense claim, but this service that you paid for, prepaid for, defends you, and you still get convicted. It's kind of crazy that while you're sitting in prison, they're going to ask you for money. So read that policy before you sign up for it. Many of them get coverage from the moment of the incident. They have a 24/7 hotline. They'll get you a lawyer right away. Some of them will cover your bail funds so that you can get a release pre-trial. But it really depends on how much they're going to pay for. So in these cases, when you need to defend yourself, especially in a murder case or something like that, you're going to want your own witnesses to counter what the government's saying. If the government is talking about ballistic witness, firearm experts, you might need your own firearm expert to talk about, the way that you were using the gun was appropriate, or maybe you fired too many shots. Some might argue that was excessive and why that might be necessary. And at the very least, you need private investigators to look into things like, the person that got killed, that person may have had a past. And while the police are supposed to investigate these things and the prosecutors are supposed to turn over exculpatory evidence, they may not look into the case as deeply as you want to. And that's why you need a properly funded defense. And so if you get an insurance policy, make sure it covers those things. Some of these policies even cover lost wages. You have to miss work for court, and you will be missing a lot of work for court in these hearings. And there's going to be a lot of psychological pressure here. Everything from just the trauma of if you were the victim of a crime, but now you're being charged with one. So occupying those dual roles, feeling victimized, and then now being accused as a perpetrator, that can be very difficult to go through. So they claim they're going to be a comprehensive safety net for the legal battle after the gun battle. I can see the value in something like that, and I can just see why that market exists, because a lot of people, more and more people own guns, and more people are using guns. I don't think the episodes of gun violence in the United States are going down. I think it's definitely going up. I think in general we have a culture of, not to editorialize too much, but there's a lot of anger and frustration out there, and people don't have the education or the emotional well-being to not commit crimes or to regulate themselves so that they don't reach for a gun and settle a dispute in a permanent way when they could just use words to talk things through. So I'm talking about incidents of road rage or things like that. That's another place where a lot of self-defense issues come up, where two people have a road rage episode, they stop their cars and start arguing with each other, and then one person pulls out a gun and starts shooting. Those things are completely preventable, and yet we see more and more of them every day. So some of the providers here that do this, USCCA, U.S. Law Shield, Armed Citizens Legal Defense, NRA Carry Guard, there's just so many of these. They have different models. Some are true insurance policies, some are prepaid legal funds, some are mutual aid funds, but they shield members from legal costs. Coverage depends. Some of them are $11 a month, some of them are $50 a month. The different tiers offer different things. I mean, $29, $39, $40 a month for USCCA's membership. $50 a month, it's like, that's basically your streaming services cost that just adds to your bill. U.S. Law Shield has lower costs, like $11 a month, but they have an add-on model. The base fee covers unlimited legal defense, but then you need bill bonding. That's going to be extra. If you need multi-state coverage, that's going to be extra. So it really depends on where you're planning on traveling with your gun and where you're going to go. Might be a little bit less if you live in Texas and get one of these services versus another state. And it's true that these might cost you a few $100s a year, but a felony defense will cost you starting at least $10,000 to retain a lawyer to handle a felony charge. And yeah, easily legal fees can be 100,000 or more, those types of cases. So, typically how it works is, you may guess it. If you shoot somebody, cops come, they dispatch, these companies will dispatch an attorney to you. They say no limit on defense costs, they'll pay whatever's necessary. But I'm wondering how they determine that. Like insurance companies will say that they will cover what's necessary, but then when the lawyer asks, like, I need more money to do something, they may deem it's not necessary, and that's exactly how health insurance companies work. Health insurance companies will decide whether your treatment is necessary or not, and they'll deny coverage on treatment, and then you just won't get that treatment. So there's somebody second guessing what's going on. So your lawyer that's appointed to you or hired through one of these companies, while they might call it unlimited, I would question that, because um, someone else might be quarterbacking the case and they have an interest in keeping your costs reasonable. Because a lawyer with an unlimited budget, they can file tons of motions and interview tons of witnesses, and they could easily take a case that might need to plea. They could take it all the way up to the Supreme Court, and that would be hundreds of thousands of dollars. So I really don't believe that there's a limit on when they mean unlimited. So you really have to question that and ask about what that means, especially if you're paying $10 a month for something like that. I just don't see that in practice. Actually, it'll give you a defense. It's just not going to give you the unlimited defense that they market. Um, some USCCA's policy provides $250,000 for bail bond expenses, which covers the 10% fee on bond as high as $2.5 million. That's pretty good. Um, if they're paying the 10%, which is typically what you have to do in a bail bond case, if the judge sets a $100,000 bond, you have to pony up $10,000 and then collateral for the remaining, I think. Um, if they provide $250 for the 10% fee, it's still questionable if you have to come up with the collateral or not to post the bond. Again, you'd have to look into all the details. Like, you really have to understand how the criminal justice system works before you uh, not hire, but pay for one of these companies, because there's a lot of hidden costs that you might not be aware of. And again, a lot of these places will say you have to have a plausible self-defense claim. But if you're the aggressor, like domestic violence situations, they're going to exclude coverage. A lot of them will exclude coverage for shootings between family members and domestic partners. They're not going to cover you if you're intoxicated or using drugs. Um, there's a lot of contracts that allow them to deny coverage if you're charged with a crime or demand reimbursement. So you need to watch that, and I talked about that earlier. Um, they also have different clauses, so their contracts do change. So they're moving away from they're getting better, where they're moving away. We only cover you if you're acquitted, to covering the legal fight until it's truly lost. And even then, they might provide appeals coverage or expungement support in some cases. And that's another thing. If they win, it's still on your record. So will they cover the expungement? Meaning, it's at least $2,000 to hire a lawyer to do that, if not more, $2,500 in the Houston area. I think that's the going rate for expungements. So even if you're innocent, you still have a record that needs to be cleaned up. So that's something to consider. Um, like I said before, there's a lot of major providers out there. They have all different kinds of plans. This video isn't really to talk about the pros and cons of these plans, because honestly, I'm not that uh, familiar. I don't sell these products. I don't use them. I just know that they exist out there. I am concerned that um, these models are not covering everything that they say. I think they recognize that, just because you've been charged with a crime and they give you a legal defense doesn't mean you're going to win. Like, you may have committed some other crime. Even if you have self-defense, you might have done something else. Uh, and I don't know what that might be. But maybe killing the person, you were cleared from doing that, but you still committed some type of manslaughter or something like that. Like, maybe there was like a certain level of intent that existed there that didn't give you a perfect self-defense case. And you may end up having to take a plea deal where, the self-defense charge is weak and they provide you the coverage, but like you may get a good plea deal to like a reduced charge, but you're not going to walk, and you have to decide whether you want to take it to trial and lose. Because just because you have insurance doesn't mean the insurance company is going to be your jury and set you free. A jury still has to do that, so they're just going to pay for your defense. They're not going to guarantee you get off the hook. So you still have to consider the different stages. And some of these members that face these charges as part of these policies, many of them, while they do get dismissals and acquittal, a certain number of them are going to get plea deals, and that's still going to save the insurance company money if it's a plea deal. But if every one of these members decided to go to trial, it would cost these insurance companies a lot of money. So I don't know if they're going to try. I don't know if they're willing to take your case to trial just because you pay for the policy. I don't think you get to dictate that. And I'm really concerned about that part as well from the ethics perspective of, do you really get to control what happens with the case if a third party is paying for your legal defense? So make sure your contract allows you that authority to do that. You're not signing that away. Now, the last part of this I want to talk about is basically comparing these self-defense insurance companies to these prepaid legal plans. So there are some plans that you can pay, like Legal Shield. They'll help you with wills and everyday legal issues, like you may have some consumer issues. Maybe the plumber didn't do the work. You have a breach of contract. The prepaid plans that are usually like $20 a month or whatever it may be, they don't do criminal defense, or they don't do serious charges. So like Legal Shield says criminal charges are excluded except for some very specific cases. So if you're charged with like a violent felony or something, they're not going to pay for your defense. Whereas these self-defense plans will pay for it. So, and some of them will only provide you 9 to 10 hours of lawyer time for a new legal matter. So even if they pay for it, they're not going to pay for the full bill. They might pay for part of it. So proper self-defense insurance would cover hundreds of hours of legal work, versus Legal Shield may not do all of that for you. And really, all these plans, like Legal Shield, for example, it's going to pay for the work. It's not going to pay for the damage of settlement. And I think that's also true for a lot of these self-defense companies as well. They're not going to pay for, if you want to settle, somebody is suing you civilly for the wrongful death of somebody, they're not going to pony up that a certain amount of cash. They're just going to provide you a defense. So another thing about Legal Shield, and this I know, is that if you're dealing with them, they have a network of providers, just like healthcare insurance companies have providers. The same thing with these plans. And those providers, just like home insurance warranty companies, they have certain vendors and they have a certain arrangement, a certain fee structure. So, a lawyer who's been practicing for a very long time that doesn't really need low hourly rates, they're just going to say, I'm not going to contract with them. So you may end up getting some good lawyers, but you may end up also getting some lawyers who just, they're just not as experienced, or this is just something that they're doing to cover the bills, but there's more, the better lawyers, you're just not going to have access to them because they're not going to be part of that network. So I think, just having a general legal plan is not going to be a substitute for these self-defense plans. And really, I guess the best question to ask at the end is, do these plans pay off? Like, when you have a high-stakes case, does it make sense just to go with your insurance plan for the average citizen? Or if you have the money, are you going to go ahead and hire your own? So the truth is, many members aren't going to invoke the coverage because they're not going to be in a situation, just like a lot of people who buy homeowners insurance for fires, they never have a fire. Average gun owner might go their entire life without a defensive shooting. And so they're going to be paying a lot of money and not really getting anything back. But the minority of people who do, that can be a lifeline that saves them from financial ruin or imprisonment. So, and imagine an average person who uses a firearm to defend a home intruder. A murder trial could be at least $100,000 in legal fees, and the bail might be $100,000 to $1 million. It wouldn't surprise me if it wasn't $250,000 to $1 million in most cases. A homeowner might have to refinance their home, drain retirement savings, rely on public defenders. This self-defense policy, the out-of-pocket legal cost is zero. So, that is worthwhile for somebody who has a gun that might plan to use it. It might be worth looking into getting these. They do seem to have successful outcomes in these cases. There's a couple of cases, the Steve and Maddox case in North Carolina in 2015. This was a USCCA member who was charged with first-degree murder. He was acquitted. This was a success story that, it was a self-defense case. Another Florida case from 2018, a Michael Drejeka case. There was a controversial parking lot shooting about a handicap parking space case. Wasn't charged at first under Florida's Stand Your Ground statute, but then it was later prosecuted. He was later convicted of manslaughter. So even though he had legal coverage, apparently it was reported that he had a legal defense fund or a legal plan. It's a little bit unclear. It's not a get-out-of-jail-free card, so if the facts don't support self-defense, you're still not going to win. And so that's what I mentioned about, a rational person is not going to depend on their insurance policy to cover them. They're just going to act reasonable regardless. I think from a perspective of a prosecutor who's been doing this for a while, that's handled homicide investigations and has prosecuted murders, and I've gotten convictions on murder cases. I think, defendants with insurance-funded counsel, they do often mount vigorous defenses because they want repeat business. They want to do a good job. But I also see in cases where, in personal injury cases that I handle, the captive counsel of insurance defense carriers, they're really doing what's good for the insurance company. I mean, I'm not going to say that they don't consider their client. They do care about the client, but the person paying the bill is the carrier. So in deciding to settle the case, they're not really looking at what may happen to the individual policyholder. They're really looking for what the insurance company wants. So they certainly act ethically in accordance with the rules of ethics, but it's just, if you think you're calling the shots when you get one of these policies, you'll be surprised to find out that you don't always. So that said, it does make the prosecution's job a little bit more challenging, which isn't such a bad thing because you want to have a vigorous defense. You want the case tested thoroughly, but it's not infallible or always excellent. So the best thing to do in these types of situations is not to be put in that situation. Some of these attorneys in the network are great, some of them are not, and you just don't know who you're going to get. And the thing is, you're not going to be able to pick the person that you want because they only use their affiliated attorneys or partner attorneys. So if the attorney you want is not in their network, you're not going to get the defense that you want. And that can also create some issues with satisfaction because really people, when they hire a lawyer, they want somebody that they trust and they get along with. So having said all of that, I think that people need to be aware of what the laws are regarding self-defense in the jurisdiction that they're in. I think self-defense insurance for gun owners is not a bad idea, especially those that specifically purchase the weapon for that purpose. But it also has limitations, and the limitations is that you don't get to choose your counsel very often. So I'm personally of the view that in these types of situations, there's a lot that you can do to really minimize your risk, and part of that is just avoiding the best self-defense, just like defensive driving teaches you, is just avoid the situation in the first place. Some people call this like a murder insurance, or it creates a moral hazard issue, but I really don't see that happening. I think people who are planning to do this kind of stuff, they're not the ones that are purchasing this insurance. They tend to be responsible people who want to avoid the outcome, and they rarely have to use it. But at the same time, there are people who have it, and they get it because they just have, that's the same reason they have a gun. They have a little bit more a personality that um, is not shy to confront people. So I don't know if insurance necessarily encourages aggression. It does encourage preparation, but for some people, they may already be in the mood to do something. Um, I wonder if the lack of insurance might cause someone to hesitate too long in a genuine life-threatening situation. So I think, in these types of situations, more than insurance is just the responsible use of guns is and the training that goes with it. I think these insurance policies, what would be great is to teach their users how to use a gun, maybe cover or offer something back in exchange, just like you can have lower premiums if you take defensive driving if their members have some kind of license or some kind of training that maybe their monthly premiums go down as a result. And I think that would make a lot of sense for people to incentivize them to do that. So that's all I really have to say on this topic. Hopefully it was insightful to and beneficial to you all listening. Just wanted to make a comment on this development in self-defense insurance that I saw was an increasing product that more and more people are buying it. It's increased greatly in the last 5 years, and I think we're going to see more and more use of it in the future. Thank you for listening. And if you like the content here, click like, and if you want to hear more of it, subscribe to the channel.